specialties. So we can't see there is any general practitioner in the cities these days. There are few left who are the old ones. New entrant into the medical field are not going in for general practice after doing MBBS. It is because of the wrong training. There is no importance of internship. There is no importance of house job training, and it is a known fact that a simple MBBS graduate these days can't even put IV cannula because they are not interested to attending the internship roster or the doing house jobs. They are all interested to take PG seats and go into the practice after doing the post graduation. This is the, I think, worst part that is changing the scene because it is more commercialized now. And government wanted to bridge the gap of patient to doctor relationship ratio, and that gap was exploited by the politician and the businessman in last 10 to 15 years. So with these words, I invite the next speaker, Advocate Dr. Hitesh Bhatt, who is presently practicing at Andheri, East Mumbai, medical legal consultant since 22 years, medical legal consultant of Wadia Maternity Hospital, Mumbai, medical legal consultant of Central Railway Hospital, Mumbai. He is partner in legal firms B&S Medical Legal Consultancies, past chairperson of Ethics and Medical Legal Committee, FOXY, 2013 to 16, authored of 2 books, Consents in Obs and Gynae, Law a Doctor Must Know, author website www.consentforthedoctors.com, invited as national faculty at many national and state conferences, delivered more than 1,000 talks, medical legal consultant to 150 hospitals all across India, served as office bearer of IMA, AMC, MOGC, AFG, and he is a life member of Film Writers Association of Mumbai. I welcome Dr. Hitesh Bhatt. Please start your talk.
So, good afternoon, everyone. See, whenever I say good afternoon, those who are awake and alive, they respond back. So, good afternoon. Good afternoon. Thank you. So, I am thankful to Mlag for inviting me here and allowing me to share my views on the topic. And also, I am thankful for creating a rare situation for me to speak uninterruptedly for 15 minutes in front of my wife. So, sir, thank you for that as well. And topic given to me is ever evolving law. So let us understand what it is. See, under the English rules, the laws were made, and it was under the influence of the church. So the sex was considered as sin by the Christians, and hence it was crime. So if it is done, and who has done it before marriage is a sinner. So even with the marriage, by some different manner, then also it was a crime. Now we know, as a result of the sin, the crime should be suffered by the doer. So every termination of pregnancy was considered as crime till 1970. The pregnant lady and the doctor both were considered as criminal for termination of the pregnancy. Now, according to our Vedas, if you see that the water, air, food and sex are the basic needs of any animal, including human beings. Any food consumed inadvertently will be excreted next day. Any water consumed inadvertently will excreted as urine in next hour. But any sexual activity done inadvertently will never be terminated for 9 months and it will come as a child. So it took so many years for these people to understand that there is a need for the law, and that they made a law of MTP Act. Now, what are the requirements under the MTP Act? We know that there are three things which are important: the place, person, and the patient. Now, as far as the place is concerned, the place has to be identified as registered by either CMO or DMO. For the person, there is a qualification required that we will see next slide, and for patient, there has to be some justification. There are indications given. And papers. You must have proper documents. Now, for place, the pregnancy must be terminated at a place which is either a government hospital or any other hospital which is recognized for doing termination. As far as the person is concerned, there are various criteria that any recognized medical qualification as defined under Indian Medical Council Act. That means only MBBS doctor can terminate the pregnancy. Then whose name has been entered in a state medical register, and also who has special training as per the law. Now, let us understand what this training is and what they have made in the law. So, additional training, RNP is conducting MTP within 12 weeks period. What is the experience required? 25 MTPs he must have done and 5 independently in a government hospital or a training institute. RMP is conducting MTPs above 12 weeks up to 24 weeks. And RMP with completion of 6 months of house surgery in OBGYN. So any person who has taken post-graduation post in a OBGYN for 6 months, and there are certain enlightened souls, they then leave that OBGYN, they join some better branch like skin VD or radiology. They also can perform MTP. Or in the event of such facilities are not available, then at least 1 year of experience in some government, in some private college, private hospital where OBGYN department is there, or degree or diploma holder for the in OBGYN. Now, for the training and experience for oral MTPs, they have added this in the recent amendment, that experience at any hospital for a period of not less than 3 months, and where he has given pills for at least 10 patients. So, these are the experience. Now, if you make a table, then this is very easy to understand that what all a doctor can do for doing terminations up to 9 weeks. All these are capable, the 3 months experience, all this, up to 12 weeks and up to 12 to 24. So, I have made a table so it is easy to understand. Now, grounds for patient. There are certain grounds in order to save the life of the women, in order to prevent grave and injury to the physical and mental health, in view of the substantial risk if the child was born, it would suffer some physical and mental abnormalities. The pregnancy is alleged by the pregnant woman to have been caused by rape, and pregnancy has occurred as a result of failure of any contraceptive device or method used by any woman. This is what is the amendment which has recently come. And termination between 20 to 24 weeks. Now, they have given various criteria: survivor of the sexual assault, minors. So, these are the indications under which we can terminate the pregnancy between 20 to 24 weeks. Now, beyond 24 weeks, they have said you can even terminate pregnancy beyond 24 weeks. The provisions related to the length of pregnancy shall not apply to termination of pregnancy by the medical practitioner where such termination is necessitated by the diagnosis of any substantial fetal abnormalities, and opinion for termination is given by the medical board. So, board will decide whether this pregnancy should be terminated or not. And for emergency, as with any other emergency, there is no rule. Anybody can terminate pregnancy if it is immediately necessary to save the life of the pregnant woman. So, rules are always relaxed for emergency. Please keep it in mind. Now, what is the difference between new law and old law? Now, up to 12 weeks previously there was opinion of one doctor, still it is one doctor, but between 12 to 20 there was opinion of 2 doctors required, now it is one doctor.
20 to 24 weeks, it was not allowed previously, now opinion of 2 doctors. More than 24 weeks was not allowed, now there is medical board which will step in. For emergency, anybody can do it, it was there before, it is there now. For infringement of privacy, previously there was 1,000 rupees fine, now it will be imprisonment for more than of 1 year or fine or both. So you cannot reveal the name of the person unless it is necessary. And contraceptive failure, which was mentioned only available to married women before, now it is available to any women. They have changed the word. So any unmarried or married, both can be included in that. Now, why the evolution in the law is required? We require it for 2 situations. Either the social circumstances have changed, the needs have changed, or the previous law is deficient. Now, the kind of people we send in parliament, we all know that why we require evolution in law so frequently in India. Because it is said that we all know that when the stomach alerts when it is empty, not the brain. And this new amendment, see the evaluation, the first, 10th August 1971, the law MTP was enacted, then it came into force in 1st April 72, rules were made in 72, 75, various regulations came by various states in 76, again it was amended in 2002 and 2003, the recent amendment came on 25th of March 2021, but still there is a confusion. There is a confusion in the mind of the doctor if missed abortion, incomplete abortion, inevitable abortion are MTP or not. And this could have been easily sorted out by proper definition of the MTP, right? They included the definition of MTP, but how? Termination of pregnancy means procedure to terminate pregnancy by using medical or surgical method. This is how they have defined it. See, for infertility they have defined that infertility means what? They have given a medical definition of infertility in ARTI. Here also they could have given better definition. But they have failed to do it. If it would have been given to me, I would have defined it like this, that notwithstanding anything contained in medical books, termination of pregnancy mentioned in this act means taking out product of conception before full term which otherwise do not require to be removed from the womb as a part of medical treatment. This is a simple definition, but it makes it very clear what is MTP. Now, as far as indication of the termination beyond 20 weeks are concerned, let us see what they have given. Sexual assault, minors, change of marital status during the ongoing pregnancy, woman with physical disability, mentally ill, fetal malformation that has substantial risk of being incompatible with life, and woman with pregnancy in humanitarian setting or disasters or emergency situation may be declared by the government. Now, if you see this, practically the survivor of sexual assault is a rape. It is as such, you can put only one word for rape. Minor, any sexual intercourse with minor is automatically rape. So it is not a different indication, it is same as rape. Change of the marital status during the ongoing pregnancy. Now what about unmarried? There can be change in their relationship. So today the situation is if some unmarried girl becomes pregnant and she is between 20 to 24 weeks pregnant and she wants to terminate her pregnancy, the only solution for her is to marry that guy. Then she will have to divorce him or she will have to kill him, because she should be either divorced or she should be widow. Then only it is allowed. Mentally ill, any sexual intercourse with mentally ill person is a rape. Again it is rape. So it all boils down to rape basically. Then they have said fetal malformation that has substantial risk of being incompatible with life. And they have not defined, they have practically said lethal disease. They have not defined what are the lethal diseases. And this last thing, women with pregnancy in humanitarian setting, like COVID, it happens once in 100 years. If any such situation arises and they fail to take abortion services before 20 weeks and it extends beyond because the healthcare facilities are under lockdown, they can naturally come out with a gazette every 100 years. Why to put it in the law? which was unnecessarily included in the law, in the amendment. And now they have not given any list of lethal diseases, as they have mentioned. Now, can we consider Down syndrome in this? Is it a lethal disease? And if you can cardiac anomaly be included where surgical outcome is good? Is it a lethal disease? There is no such clarity. And if you ask some, we should consult some pediatric surgeon for the opinion, what to do. And if you see spiritually, life itself is a lethal disease. It eventually leads to death. So what to do? That means you can terminate any pregnancy. Now about punishment. They have mentioned punishments, and here they have added, as I told you, for contravention of provisions of subsection 1, that is, no registered medical practitioner shall reveal the name and other particulars of a woman whose pregnancy has been terminated under this act, except to a person authorized under any law. Now many PCP and DT authorities, ART authorities, they are coming because they are same authority, and they are asking for MPP register every month. And some places they are taking pictures also. They are taking Xerox also of that register. Is it not infringement of privacy? And if you do that, you are liable for 1 year of imprisonment. Now what to do? What is the protection for a doctor? That is not clear in the law. Now, when pregnancies may be terminated by registered medical practitioner, this is the provision which is there in the MPP Act, and it is a good act, it is protective act. It says that nothing, notwithstanding anything contained in the Indian Penal Code, RMP shall not be guilty of any offence under that code or under any other law for time being in force if pregnancy is terminated by him in accordance with the provisions of this act. But there were 2 cases which I fought, Dr. Jaju, where we got successful outcome, and one more case is going on against a doctor at Pune under Indian Penal Code. Now they have terminated pregnancy and they are having MPP license, they have proper indication. Only thing, the husband has filed the case against the doctor saying that this pregnancy was terminated without my consent. So section 312 was applied. Now we showed this to the court to get the first case out. The court did not consider this. There were other arguments and we had successful outcome, but this is a protective provision in the act. But it was not into operation when it comes to a justice. There is section 8 also in the act. No suit or other legal proceeding shall lie against a RMP for any damages caused or likely to be caused by anything which is in good faith done or intended to be done under this act. So even consumer case cannot be filed if it is done under the good faith, and it is her wish we are fulfilling. She wants to terminate the pregnancy. If there is perforation, they should not go for any claim for compensation under this. But still there are many cases in the consumer court as well going on against the doctor for not having a proper outcome. And this is not operational. So practically, this is the situation, as futile as this treadmill exercise by this man. The protection given under law is like this. So friends, Winston Churchill has said that to improve is to change, and to be perfect is to change often. And I also say that only 3 ways you can change the law. Any law which is not good for you, you can, by 3 ways you can change. The first way is you should have proper representation in the parliament. And sitting there, you can change the law, which is not a case for us. Second way is way of agitation. You come out on the road, you have seen farmers, they got the government bow down and took back the provisions which were against them. So that can be done, but that is also not possible for us because we are busy. The third way is by filing various cases in the court and get the favored judgment in your favor. And that work is done by Mlag. So this is Mlag working for you. He is Mr. Neeraj Nagpal, not a Nai. You are busy, but what he will do for you, you just have to donate and he will do his job. Even if you are busy, even if you are going for your visits, your practice, anywhere, but he is constantly behind you, working like this. So at least support this association and make the changes in the law. So friends, I always tell, if you are not in agreement with any act, you have to show your disagreement. बात अगर उसूलों पे आ जाए तो टकराना जरूरी है, अगर जिंदा हो तो जिंदा नजर आना जरूरी है. Just continue your journey, not only walking but dancing like this baby. And thank you very much. Thank you for patient hearing.
Next conference onwards, there should be 2 awards, one for the best slide, visual slide, and one for the.
Thank you, Dr. Hitesh Bhatt, for your very interesting presentation for the medical termination of pregnancy and